Hello, welcome to our Chapter 7, Section 3 notes. Chapter 7, Section 3 is about the U.S. Supreme Court, and it begins on page 189 of our textbook. Before we read, we should keep this main idea in mind. The Supreme Court hears appeals, reviews laws, and strongly influences American society. Key terms we should know when we finish this section are judicial review, remand, opinion, concurring opinion, and dissenting opinion, and three questions to keep in mind as we read. One, what is the power of judicial review? Two, what are the constitutional checks on the Supreme Court's power? And three, how has the Supreme Court strengthened constitutional rights? So we begin with the power of judicial review. So the idea of judicial review means the US Supreme Court can look at laws passed by Congress, signed by the president, and the Supreme Court, if the cases go all the way up from district court to appellate court to the US Supreme Court, if the Supreme Court decides that that law is unconstitutional, that if the law passed by Congress does not fit with what it says in the Constitution, through judicial review, judges reviewing, or the justices of the Supreme Court reviewing the decision, the Supreme Court can say that law is unconstitutional because of judicial review. Let's say, for example, that the Congress, both the House and the Senate, through the long process of passing a bill into a law that we talked about in the legislative branch, let's say that they pass a law saying you cannot make fun of, no one in America can make fun of the President of the United States. Now, Congress passes that law. The President signs that law. A lot of people would say they can't do that. The First Amendment says I have the freedom of speech. But they did it anyway. Because who decides what freedom of speech means? So that really is up to the interpretation of the law. What do those words mean? And of course, who does the interpreting of our laws? The judicial branch of our government, and ultimately the US Supreme Court makes those decisions. So the US Supreme Court has this power of judicial review to say a law is unconstitutional. But what's interesting is that power of judicial review does not exist anywhere in the Constitution. The Constitution does not explicitly give the judicial branch the power of judicial review. Instead, way back in 1803, in a court case called Marbury versus Madison, the Chief Justice of the US Supreme Court, a man named John Marshall, he in effect created the power of judicial review and decided that the Supreme Court had this power, had the court rule an act of Congress unconstitutional, and basically everyone lived with that decision. And then ever since going forward, because of precedent, because of a decision already made, and common law, and the power of the US Supreme Court, all court decisions since then, all US Supreme Court decisions since then, have had as part of their power the sense that judicial review meant the court could rule other acts of Congress unconstitutional. So the Supreme Court itself, as we looked at in the last chapter, is both an appellate court. It hears appeals from lower branches or levels of government, of courts, and it is also a court of original jurisdiction. It hears a very small number of cases for the very first time, states suing states, for example. But as an appellate court, hearing decisions that started off in federal district court, were appealed to appellate courts, came to the very top of the US Supreme Court, they have, as a Supreme Court, over 7,000 cases are filed every year to be heard at the US Supreme Court, out of which the US Supreme Court only hears between 130 and 150 in many years. Sometimes the court just simply says, no, the appellate court decision stands and throws it back, and whatever the last court to hear it said, that is the settled law. That's the final answer from the court system. Other times the Supreme Court will remand the case, which is just another word for return the case, to a lower either district or appellate court and say, hey, new trial or new interpretation of the law, we're not going to do it, but you guys rehear the case and do it over again. So that's remanding the case. Obviously, the vast majority of those 7,000 cases are simply the court says, no, we're not going to hear it. And so the appellate court's decision stands. But then, of those 100 or so cases that the court does, in fact, hear and decide on every year, the US Supreme Court is deciding some of the most important cases in the United States. How does it do that? So it actually calls lawyers up to argue the case in front of them. There is no jury. Those 9 justices, the 9 people who sit on the Supreme Court, are the jury and the judge of the case. There are no more witnesses. There are only 2 lawyers who, or there can be several lawyers on each side, but each side gets 30 minutes to argue their case. So to argue in favor of whatever law it is, one side spends 30 minutes arguing, and then whatever side says, no, that law is terrible, it's unconstitutional, the other side then gets 30 minutes. The justices will then take those oral arguments, as they're called. They'll take lots and lots of written arguments as well. They will go then and think about those cases, argue amongst themselves in private what the outcome of those should be, and then finally, oftentimes after several months, they will come up with an opinion of that case, which will say this side or that side wins. The law is unconstitutional and we throw it out, or the law is constitutional and all is fine. So they will deliberate and vote and come up with an opinion or a decision in the case. Typically, one justice writes the opinion and says, this is what the Supreme Court thinks. With 9 justices, of course, at least 5 have to say that to be the majority and write a majority opinion. Sometimes maybe 4 of those justices will all agree with the same argument, but one, although they'll vote the same way, actually has a different argument for why that's true. So in that case, that other judge or justice can write a concurring opinion, like an opinion that agrees with the majority opinion, but is different than the majority opinion. That all differs from the dissenting opinions. So some justices often lose their side of the argument. They strongly disagree with what the majority has decided. Let's say the 4 members in a minority in a case are outvoted by the 5. The 5 write the opinion of the court. Maybe one writes a concurring opinion. Anyway, and then the other 4 think those 5 really screwed up. Those 4 may very well write what is called a dissenting opinion and just say, here's why we think the Supreme Court is wrong in this decision. But all that really matters is the majority opinion, because that's the ruling of the US Supreme Court. So there are 9 justices of the Supreme Court currently, but only because Congress says so. Congress could say there's going to be 100 justices of the Supreme Court, and there would be. That would be too many and unwieldy. And we have had 9 justices ever since 1869, so for a very long time. But in the 1930s, President Franklin Roosevelt at the time, he had a plan to add justices to the Supreme Court, that he actually changed his mind sort of at the last second in a famous bit of Supreme Court history in presidential American history. But anyway, we have 9 justices of the Supreme Court for a very, very long time. That is not, though, in the Constitution. That could change, although is unlikely to. The president also then picks one of those justices to be the Chief Justice of the Supreme Court, the sort of chief of those 9 people. They do not get an extra vote or anything, but they sort of decide who gets to write the majority opinions when the Chief Justice is on the majority side. They also sort of lead the arguments when there are oral arguments happening between the pro and con sides of any case before the US Supreme Court during oral argument. Supreme Court justices are appointed by the president for life, just like all other federal judges. They also have to be confirmed by the US Senate, just like other federal judges. So because they are appointed by the president, confirmed by the Senate, in that way, checking the court's power, the president and the Congress, at least the US Senate, have some power over the US Supreme Court. Although, of course, the court can rule a law unconstitutional. And so that is the judiciary's power over the legislative and executive branches. Again, interestingly, not specifically mentioned in the Constitution, but that power of judicial review basically created by the court itself early in our constitutional history. There are other ways, though, that the Congress and the president can attempt to override the US Supreme Court to check the power of the Supreme Court's power of judicial review. And that is, they could go simply pass a different version of a law that is ruled unconstitutional. If the Supreme Court says the law is unconstitutional for these reasons, well, the Congress could come back and pass a very similar law to use these reasons just over here in an attempt to get around the Supreme Court decision. Now, the Supreme Court, through a process of appeals, could maybe hear that law again and once again rule it unconstitutional, but that's Congress's ability to try to get around Supreme Court decisions. And then, of course, lastly, the most important way to check the power of judicial review, to check the power of the US Supreme Court, is if the Supreme Court rules a law unconstitutional, well, by golly, you could change the Constitution. So this happened exactly in that way with the income tax. So in 1895, Congress passed a law that said we're going to put an income tax on Americans. The US Supreme Court heard that case after it was brought to district court, appealed to the appellate courts, appealed all the way to Supreme Court, and the US Supreme Court said, oh, that's unconstitutional. Nowhere does the Constitution give Congress the power to impose an income tax. So guess what happened? About 18 years later in 1913, the Congress got together and pushed politically and had the support of enough states that a constitutional amendment was passed, the 16th Amendment, that said income tax is constitutional and legal in the United States. So now, of course, the Constitution itself was changed to say that a income tax is in fact constitutional. Well, there goes any argument the Supreme Court had that it was unconstitutional. It says clear as day that it is now constitutional. So that is the sort of ultimate check on the Supreme Court's power to interpret the Constitution, is to, of course, change the Constitution if necessary. So the last page of our Chapter 7, Section 3 notes, and believe it or not, the last page of all of the text that we will cover together in notes happens on page 192, and it discusses strengthening rights. And it talks about sort of the social and cultural power the Supreme Court has had, as well as political power, to try to shape American society. And so it talks specifically about the Brown versus Board of Education Supreme Court decision in 1954. In 1954, in that Supreme Court case, the US Supreme Court said segregation of public schools was unconstitutional. So in that particular case, Topeka, Kansas had black schools and white schools. And African American children could not go to the white schools and vice versa. And some parents brought a lawsuit and said this is unconstitutional. And it went to an appellate court, and then it went finally to the US Supreme Court. And in 1954, the US Supreme Court said that segregated schools, school districts saying specifically black and white schools, that violates the Constitution. Now, nowhere, of course, in the Constitution does it specifically say that. It doesn't talk about schools anywhere. It doesn't talk about segregation or desegregation anywhere. But all of the other rights listed in the Constitution have come to mean to the US Supreme Court by 1954 that American society and our Constitution itself, read for the times, updated in effect to 1954, mean that all men are in fact created equal, and that all men and all women are in fact created equal. And so skin color and gender are not ways we can limit someone's constitutional rights. And so that notion of expanding constitutional rights has really expanded through time. And so sexual orientation, the right of gay marriage is a much more recent US constitutional decision. Some states said marriage was illegal. Congress said gay marriage was illegal. And the US Supreme Court stepped in and said those are unconstitutional laws at either the state or federal level, and they have to be thrown out. And two men or two women should be allowed to marry each other. The text itself also talks about Miranda versus Arizona back in 1966. A criminal defendant has to be read his or her rights. Throughout the 60s, the Supreme Court expanded voting rights, representation in Congress, civil rights, lots of other issues that the US Supreme Court has stepped into over time to, in many people's minds anyway, expand those rights. Abortion is another very controversial area where the US Supreme Court in 1973, with a decision called Roe versus Wade, stepped in and said, under certain conditions at certain times, a woman in the United States has a constitutional right to an abortion. So that's a little bit about how the US Supreme Court has been viewed to strengthen rights throughout time. Some people disagree with some of those, of course, but overall, the US Supreme Court seems to have applied more and more broadly over time those fundamental constitutional rights of life, liberty, and happiness, which is in our Declaration, but of all men being created equal, which is in our preamble to our Constitution, to all of those things that both the legislative and executive branches have passed over time. So that concludes our look at the judicial branch. And that concludes our look at the US government in our civics class for this semester. I hope you learned something. I know I did. And if you have any questions, of course, please come prepared to ask those. Thank you so much.